If you were bitten by a dog in Florida, you probably have two questions running at the same time. One, can I make the owner pay for what happened to me? Two, why is the insurance company already acting like this is somehow my fault? I'm Doug Burnetti. I'm a personal injury lawyer in Florida, and I've been doing this type of injury work for over 30 years. In this video, I'm going to show you what it really takes to prove negligence in a Florida dog bite case, step by step in plain English. And just as important, I'm going to show you the traps that can shrink your claim fast, like the bad dog sign, provocation arguments, and Florida fault rules. Florida is not like a lot of states. Florida has a strict liability dog bite statute. In plain terms, that means the owner can be responsible even if the dog has never bitten anyone before. The core law is in Florida Statute 767.04. It says in general, if a dog bites a person while that person is in a public place or lawfully in a private place, the owner is liable for the damages. Lawfully matters. If you were invited over, if you were there for a normal reason, or if you were doing a job you're allowed to do, that can qualify. Quick example. Think about the mail carrier delivering mail, the Amazon driver dropping a package, a utility worker reading a meter, or a guest at a backyard barbecue. Now, strict liability is a powerful starting point. But here's the part most people do not find out until the insurance company starts fighting. Strict liability does not mean automatic full payment, and it does not mean the other side cannot try to reduce what you recover. That's where negligence comes in. So why are we even talking about negligence if Florida has strict liability for a dog bite? Because negligence is often the difference between a lowball offer and full compensation, a clean win and a messy blame game, getting paid and getting shut down by a legal exception. Let me give you the biggest example. Florida Statute Section 767.04 includes a bad dog sign rule. If the owner had a sign posted that easily reads and says bad dog, the owner may not be liable in certain situations. But there are major limits, including this. The sign exception does not apply the same way to a child under 6. And the sign does not protect the owner if the damages were proximately caused by the owner's negligent act or omission. That last part is huge. Translation: sometimes to win despite a sign, you need to prove negligence. Second reason negligence matters. Insurance companies love to argue that you contributed to the bite. In Florida, your percentage of fault can reduce your recovery, and if you're found to be more than 50% at fault, that can completely stop your recovery entirely. In many negligence cases, if someone is found greater than 50% at fault for their own harm, they cannot recover any damages. So if the defense can push you over that line, they don't just reduce the claim, they try to erase the claim. That is why negligence is not an academic concept. It is how we protect your case value. Negligence means someone failed to use reasonable care and that failure caused injury. In a dog bite case, we're looking at whether the owner did something they should not have done or failed to do something they should have done, and that mistake led to the bite. Here are the 4 parts we build like a chain. Number 1, duty of care. Number 2, breach of duty. Number 3, causation. And number 4, damages. Let's walk through each of them with real-world examples. Start with duty of care. Duty is simple. What was the dog owner supposed to do? In most situations, a reasonable owner should control the dog, secure the dog, warn people appropriately, separate the dog from guests if there's a risk, and fix obvious escape routes like broken gates or fences. Imagine you're invited to a friend's house. You're doing nothing wrong. You're standing in the kitchen. The dog is pacing, whining, and staring. A reasonable owner recognizes that as a warning sign. Reasonable care might mean put the dog in another room, use a leash inside, or tell guests not to interact with the dog and supervise closely. That is duty. Remember, duty equals reasonable steps to avoid or prevent a bite. Second is breach of duty. Breach is where we ask, did the owner fail to act reasonably? This is where dog bite cases get very specific. Common breaches we see: leaving a door open when the dog should have been contained, letting a dog roam off leash in an area where people are close by, ignoring repeated complaints that the dog growls, lunges, or escapes, failing to repair a broken fence or gate, letting a dog interact with children unsupervised when the owner knows that is risky. So imagine this: you're at a neighbor's barbecue, everyone knows the dog gets anxious around strangers, so normally the dog is kept inside. This time the owner says he's fine, leaves the back door open and walks away. The dog bolts out, clamps onto your leg, and you end up in urgent care. This is a breach because the owner did not do what they normally do to prevent the exact thing that happened. And here's the key point: breach is not only what they did, it is often what they failed to do. No leash, no warning, no separation, no gate repair, no supervision. The third element is causation. Causation is the connecting of the dots. We have to prove that the owner's breach of negligence or breach of duty is what led to the bite or caused the bite. A simple way to think about it is, if the owner had done the reasonable thing, would this bite still have happened? Imagine a dog is showing stress signals. The owner leaves you alone with the dog anyway. The dog bites. If the owner had secured the dog or stayed present and intervened, the bite likely did not happen. That's causation. Now here's where the defense tries to cut the chain. They may claim you caused the bite by provoking the dog. They may claim you ignored warnings. They may claim you were not lawfully on the property. This is why facts matter and why early evidence matters. Because once the story gets muddy, the insurance company will use that to fog you down to a lower value. The fourth element: damages. Damages would be the harm that you suffered. This is not just did it hurt. This is the real cost of what happened. In dog bite cases, damages often include ER and doctor bills, stitches, surgery, and follow-up visits, infection treatment and medications, plastic surgery or scar revision, lost wages and missed work, reduced earning ability if the injury limits your job, pain and suffering, emotional distress, anxiety, fear of dogs, scarring, and disfigurement. And here's something people underestimate: a bite can change your daily life, how you sleep, how you exercise, how your kids feel around animals, whether you feel safe walking your own neighborhood. Those are damages too. And God forbid, if someone was killed, there's damages that their survivors can seek, such as medical bills, funeral expenses, pain and suffering of the survivors, and those types of damages. Let's talk about the defense playbook. Number one, provocation. They will look at any way to say you teased, hit, startled, or challenged the dog. Number two, trespassing or unlawful presence. Florida's strict liability law is strongest when you were in a public place or lawfully on private property. Number three, comparative fault. This is the big one. Under Florida Statute Section 768.81, fault can reduce damages, and if you're found greater than 50% at fault in many negligence actions, you may be barred from recovering anything. Fourth, the bad dog sign argument. Under Florida Statute Section 767.04, a readable bad dog sign can change the case in certain situations, but it does not automatically end the claim, especially if negligence by the owner is involved or a young child is involved. When you know these defenses exist, you can see why negligence is still so important. Negligence is how we prove the owner had a preventable safety failure, even when they try to shift the blame. If you or someone you love is bitten, here's what I want you to do. Get medical care immediately. Bites can get infected quickly, and medical records become the foundation of your case. Report the bite. Animal control reports create an official record. They also help document the dog's history. Identify the owner and the dog. Get names, addresses, and any insurance information if available. Take photos and video. Your injuries the same day, the next day, and throughout healing. The location, the gate, the fence, the leash, the lack of leash, the sign, the lack of sign. Get witnesses' names and numbers. Neighbors, guests, delivery workers, co-workers, anyone who saw it. Watch what you say to the insurance. Be careful with recorded statements. The wrong wording can be twisted into provocation or you admitted fault. And one more reality check. Do not wait. Florida has deadlines. Evidence disappears, witnesses forget. And Florida statutes section 95.11 sets a 2-year limitations period for actions founded on negligence, with different deadlines for different types of cases. So even if you do not know yet whether your case is big, protecting your options early is smart. Let's recap. Here's the takeaway. Florida gives bite victims a strong starting point with strict liability under Florida Statutes section 767.04. But getting full fair compensation often comes down to proving negligence clearly. What the owner should have done, what they failed to do, how that failure led to the bite, and how the bite changed your life. If you do that, you don't just have a story, you have a case. Please don't take my discussion of dog bite injuries as negative about having pets. I have pets, and I know many people that have pets. The issue is not whether you have a pet that you love and that you care for. The issue really is about if someone's injured by that pet. Now, dog bite injuries are not the only claims where timing and evidence can make or break your recovery. Truck accidents in Florida can be even more aggressive because trucking companies move fast to protect themselves, sometimes within hours. So if you want to know exactly when you should consult a truck accident lawyer in Florida and the early mistakes that can cost you money before you even realize it, watch the next video on your screen. It will help you protect your claim before the other side starts building theirs. See you there.